The major steps in formation of a company are: number 1, promotion stage. Number 2, registration stage. Number 3, incorporation stage. And finally, commencement of business. Let us discuss these steps in detail. First of all, let's discuss about the promotion stage in detail. So, promotion is the first step in the formation of a company. In this phase, the idea of starting a business is converted into reality with the help of promoters of the business idea. And also the promoter is a person who brings the company into existence. In this stage, the ideas are executed by the help of promoter. Now, let us discuss the legal status of the promoter. The position of a promoter is termed as quasi-trustee. This is because of the fiduciary position he has with the company he is promoting. A fiduciary position signifies a position of trust and confidence. The promotion stage consists of the following steps. They are: number 1, identify the business opportunity and decide on the type of business that needs to be done. Secondly, he perform a feasibility study and determine the economic, technical, and legal aspect of executing the business. Thirdly, interest shown by promoters towards the business idea shall supply capital and other necessary procedures to start the business. The duties and liability of the promoter are given below. Firstly, the promoters must not make any secret profit at the expense of the company that is being formed. If any such secret profit is obtained, the company can claim the benefit from the promoter. Secondly, the results of all the negotiations entered into by the promoters on behalf of the company should be given to the company itself. If promoter appropriates any such benefits, the company is entitled to claim that. Thirdly, when the promoters enter into any contract with the company, directly or indirectly, any interests or profit on the part of the promoters should be fully disclosed to the company. The promoters should not cause any undue influence or fraud over any contracts with the company. They should not make any unfair use of their position. Finally, they should ensure that the prospectus does not contain any untrue statements. Remuneration of promoters. The promoter is entitled to a reasonable remuneration for his services. The company pay him a lump sum amount for his services. In the leading case of Gluckstein vs. Barnes and Lidney vs. Bird, it is clearly states that the company may be able to sue the promoter for damages for breach of fiduciary duty. In this case it is stated that the disclosure by the promoters should be explicit and complete, otherwise, the company may set aside the same and claim damages from the promoters. The promoters are liable for secret profits and the liability arises as soon as the company is formed. The promoters should not make any secret profit from the company. The second stage comes the registration phase. Registration stage is the second part of the formation process. In this stage, the company gets registered, which brings the company into existence. A company is said to be in existence if it is registered, as per the Companies Act, 2013. In order to get a company registered, some documents need to be provided to the Registrar of Companies. There are several steps involved in the registration phase, and are as follows. First, 1. Memorandum of Association. A memorandum of association must be signed by the founders of the company. A minimum of 7 members are required in case of a public company and 2 in case of a private company. The memorandum of association must be properly registered and stamped. Secondly, Article of Association. Article of Association is also required to be signed and submitted. All members who previously signed Memorandum of Association should also be signing the Article of Association. The next step is preparing a list of directors, which should be filed with the Registrar of Companies. Fourthly, Directors of the company should provide a written consent, agreeing to be directors, should be filed with the Registrar of Companies. Fifthly, the notice of address of the office needs to be filed. And finally, a statutory declaration should be made by any advocate of either the High Court, or Supreme Court, or a person of the capacity of Director, Secretary or Managing Director. This declaration shall be filed with the Registrar of Company. Next comes the third stage, that is, the Certificate of Incorporation. Certificate of Incorporation is issued when the Registrar is satisfied with the statutory requirements regarding registration have been duly complied with. If the Registrar is satisfied, he retains and registers the memorandum, the articles and other documents filed with him, and issues a Certificate of Incorporation. By issuing the Certificate of Incorporation, the Registrar assures that the company is incorporated and, in the case of a limited company, that the company is limited. This certificate validates the establishment of the company in the records. And finally, the final stage, that is, Certificate of Commencement of Business. Certificate of Commencement of Business is required for a public company to start doing business, while a private company can start business once it has received the Certificate of Incorporation. Public companies receiving the Certificate of Incorporation can issue prospectus in order to make the public subscribe to the share for raising capital. Once all the minimum number of required shares have been subscribed, a letter should be sent to the Registrar, along with a bank document, stating their receiving of the money. The Registrar will issue a certificate, upon finding the provided documents satisfactory. This certificate is known as Certificate of Commencement of Business. The company can start business activities from the date of issue of the certificate, and the business shall be done as per rules laid down in the Memorandum of Association. So, the Certificate of Incorporation shall be considered as a conclusive evidence that all the requirements of the Act have been complied with in respect of registration. The company is duly registered. The company will came into existence on the date mentioned in the certificate. This concludes the topic of formation or incorporation of a company, which is an important concept for the students of commerce and LLB.